Who is this for? If you are a business, you are providing goods on credit, you need to think about whether or not protecting yourself by way of a PPSR security is for you. If you're in the business of providing finance.
If you're a director who has loaned money to your company, you definitely need to start thinking about whether you have appropriately secured repayment of that money. Otherwise, you are giving your company your money. It doesn't have to pay back.
That's right. So you put in place all these asset protection strategies, but for a simple registration, the whole thing is been a waste of time. So you are expected to know your businesses. The responsibility to protect yourself rests with you.
Angelina Kozary. I am a lawyer and a partner at the firm Holman Webb, which is a national full-service law firm.
Some recent things that we've been seeing in the profession, and in particular around personal property securities. And I was commenting to her that in administering the matters that we've been working on, I'm starting to see a real decline in the use of the Personal Property Securities Register. And I thought today would be a really great opportunity to have a chat with Angelina about what the Personal Property Securities Register is and how it's supposed to work and what happens when it goes wrong.
Thanks, Liam, and thanks for inviting me in to talk about this. I thought maybe we could start about talking to exactly what the Personal Property Securities Act is.
Please.
Because that's obviously the best starting point. So, in the same way that you can register a mortgage on the title of someone's house, assets that are not real property can also be subject to security that is granted to, say, secure repayment of a borrowing, or to give someone priority to be paid out of a pool of assets. The Personal Property Securities Act deals with any registration of security that is not over real property. So that can be a registration over things as diverse as money in bank accounts, right through to intellectual property. And it also covers something that's really important in the building and construction industry, which is retention of title. So if you are selling goods to someone and you have not received payment for those goods yet, you can actually have included in your terms and conditions that title does not pass until payment is made. To secure that provision in your contracts, or to give security for that provision in your contracts, you then register a security interest on the Personal Property Securities Register, which is dealt with under the Personal Property Securities Act. So basically that gives you a mortgage over an asset that isn't real property, that isn't land, that isn't a house. And it's a really great tool to protect yourself and to give people security when they are advancing funds or giving credit to their customers or to their clients effectively.
So how it often works is when we're appointed as administrators or liquidators, there is a presumption that any of the assets in the control of the company that we're appointed to are in fact assets of the company and are available to be realised and sold for the benefit of creditors generally. Unless, of course, there is a security registered on the Personal Property Securities Register that is a valid registration of a valid security, in which case the interest of the secured party trumps other creditors. And if that security is not there, you lose your priority, you lose your protection that you were expected to be receiving when you provided finance.
So like when you've got a house with a mortgage over it, the bank who gives you the mortgage gets paid first. And it's the same thing with security registrations on the PPSR, which is the Personal Property Securities Register. But I think let's refer to it from here as the PPSR. It's a lot quicker to say.
Then maybe you could tell us a little bit about what are the essential elements to have a valid security that would stand up in the event that a company is in liquidation.
Sure. The most important thing when it comes to registering a security interest, and there's an insolvency event that happens, is timing. So you must register your security interest within 20 business days of the grant of the security. So if you enter into a contract that charges all of the present and after acquired property of your customer. And that's what it's usually how it's usually referred to in terms of a registration. That's when you are securing over everything that someone owns. Then you have to register that security interest within 20 business days. And if you don't, and the company subsequently goes into liquidation in the next 6 months, your security interest is valid. So you either have to register, if you're going to register late, make sure there's 6 months before that company goes into liquidation administration. So you have to make sure that that happens within 6 months of a liquidation or administration. The best way to deal with this, though, is to just ensure that within 20 business days, your security interest is granted. So then there's this special type of registration, which is a purchase money security interest, which we call a PMSI, gives you this super priority. So if you are giving credit for the purchase of an item,
usually like a vehicle is the most common type.
Yep, and you have a super priority and a PMSI registration over that specific asset. It's not so general. Your PMSI will trump any registration over all of the assets of the company, which is a general registration over all of the collateral. It has to be registered within a different time frame. So if the inventory has not yet gone to your customer, so if the car has not yet been delivered, you register it before the car is delivered. If the car has already been delivered, then in that case, you have to register within 15 business days. Otherwise, you come across the same issues with respect to timing that you would on a registration over all of the property of the company.
So in a general sense, if the company's obtained finance from a bank or a financial institution, the bank might take out a security on the Personal Property Securities Register, which covers all assets of the company. But if you then subsequently obtain finance to buy a vehicle from an alternate finance provider, they might register the PMSI specifically against that vehicle. And the PMSI would mean that the vehicle gets sold to pay back the finance provider for the car, with the balance of assets being available for the bank under their security.
So you can have two registrations. It's not just the one. So you can have a security interest over all of the property of a company and a specific security interest that might be a PMSI or it might not be a PMSI over a specific asset. So some lenders, for example, will take a security over all of the assets of the company and also a specific security interest over a particular fixed asset of the company or an asset such as shares that are held by that company. And it sounds complicated, but if you think about it in terms of just the person who's providing credit doing everything that they can to make sure that they get paid, it's really just shoring up their position.
On day one of an appointment, and quite often beforehand if it's a voluntary appointment, we will pull a search of all the securities registered against the company as part of planning how to deal with the administration. And as time goes by, that list of securities has gotten longer and longer, quite often because creditors don't discharge their securities when debts are repaid. Within 24 hours of appointment, we're required to write to every secured creditor and ask them to confirm that they are still in fact owed money, that their security is still valid, to provide us with documents to support the validity of their security, and to identify assets that they hold security over. What we've started to notice lately, though, is the number of creditors who have come forward and thought that they were secured and are not. And this has created quite the problem for them.
The biggest problem I see, and I'm sure you see it too, Liam, is that people just seem to forget about registering. That's the first issue. The second issue is that people think that just because it's in a contract that they have security, and they don't. You need to register that security.
I think the third issue that we've seen is that people have become lazy or complacent about this legislation. They have pro forma templates for the securities that they're creating, and they think that they can just quickly slapdash a registration on the register, and then when it comes time, it is inaccurate or inadequate to properly register their interest, and accordingly, when we're appointed, that interest ceases to exist.
So what happens when those interests cease to exist is that you lose the security that you had. It would be like the bank forgetting to register a mortgage over your property and then you sell it.
So in the simplest case that we've seen recently, it had a finance provider. It had provided finance to the company to acquire a Ford Ranger. About 9 months after the company acquired the vehicle, the company went into liquidation. The security was registered that what was registered was grossly inadequate and in fact was therefore void. Accordingly, that vehicle got sold and the net proceeds went into the general coffer available for creditors, as opposed to the secured creditor getting the sale proceeds back to pay out the debt that was owed to them. However, that's a fairly simple case and probably in the overall scheme of things fairly minor, but it can be so much significantly worse than that. Angelina, what's probably the worst case that you've seen?
I think we've worked on a matter together where there has been a failure to register in time that has resulted in a large bank not being able to recover any of the money that it had loaned to the company as a priority creditor. Now, that bank then had to join the pool of unsecured creditors, which meant that it would just get paid cents in the dollar. Unfortunately, in that liquidation, there were no recoveries, and so the bank ended up receiving nothing. That's a pretty major mistake from an entity that has in-house legal teams who are solely responsible for maintaining the register. Not the biggest example I've ever seen, but the most painful. I come from a small business background and many of my clients are small business owners, and the amounts might not seem great that we're talking about. It's not millions of dollars, but I've had clients who have had retention of title clauses in their contracts and they have failed to register, thinking that those retention of title clauses will protect them and they can just go and take their assets back if the company goes into liquidation. And even when these are, $50,000, $100,000 worth of goods, makes such a huge difference and has this huge flow-on effect. And so one of the things that I like to do when I onboard new clients generally is talk them through how I can help them get their terms and conditions up to date and teach them how to register their own security interests on the PPSR so that they can make sure that they have security in these situations. It's less of a mistake than just not knowing that the PPSA and the PPSR exist to protect them. The other thing I should say is that registering a security interest is so cheap. It's really not an expensive process. And you can register them for a short period of time. I believe it's around 7 years, or a long period of time around 20 years, and the cost is different between those registrations. But it's not an expensive exercise, especially for retention of title registrations where you only need to really make it once in that very long time frame.
So the absolute horror story that I'm aware of is a company that had failed to register securities in relation to vehicle finance provided. When the company that went into liquidation, the liquidator sold those vehicles, the revenue went into the general pool. Because that creditor did not receive the money back that they were expecting to on the finance of the vehicles, it actually drove them into liquidation as well. So the consequences of getting this wrong sometimes are minor, but sometimes can be really severe. And I think when you think about how simple the Personal Property Securities legislation has made it to register a security and have that security be enforceable in the event of a default or a liquidation scenario, and the really minor costs associated with it, it's a bit crazy that people have become complacent about protecting themselves.
And look, I think there's two other really big things that we need to make people aware of. The first is that if you don't have security over all of the present and after acquired property of a company, and therefore over the majority of the assets of a company, you don't have the right to appoint a receiver. So this extends to directors who have made loans to their companies and who have taken security over their companies. But a personal property security registration over all of the assets of the company will invariably allow the appointment of a receiver over a company, which can be used to assist to recover a liability, even if it's direct loan. The second thing that I think that I wanted to make sure people know about is priority. First in time, first in line.
Yeah, that's right.
So if you forget to register and someone else registers before you, then you sit behind them on the scale of who gets paid first. So it's really important to remember that unless you have a PIMSI, if you just have a general registration, it's first in time, gets priority.
And like we said, considering the ease and the small cost associated with this legislation, it really is in everybody's best interest to get proper advice from a qualified solicitor in this area, like Angelina, and make sure that you are protecting yourself in the event that the worst happens.
And like I've said, I can teach you how to do your own registrations. It's not something that you need to engage a lawyer to do every time you onboard a new customer. It's something that you can do yourself and with minimal training. Liam and I can come in and do training for your staff so that you understand how to register these security interests properly and what the pitfalls are. We can work with your accountants to set these things up. There's so much that we can do to help you that doesn't require a huge spend.
So check out the link at the bottom here. I've a bit of a fact sheet about the essentials of personal property securities legislation, and also Angelina's details. If you've got any questions about securing your position, please don't hesitate to get in contact. Angelina, thank you so much for coming along today. It's been really useful.
Thank you for having me. I hope we've given some value to your contacts in protecting their interests and recovering all the money that's owed to them.
Thanks, guys. Got any questions? Get in touch and we'll see you next time. All right. Today I'd like to introduce Angelina Kozary.
Kozary.
What? Damn it.
Hi, everyone. Is that the most
Yeah. Hi, everyone. It's great.
When is the PIMS?
I thought it was still 20 days.
Can I just check that?
Yeah,
yeah,
absolutely.
I'll hit it.
Security registration.
I don't do it yet because
Don't do that?
her and we've got
Oh, yeah.
Securities interest.
Personal money security.
Is it personal?
Yeah.
Okay. There's,
Actually, now you say that. I'm like, yeah, it is.
I just call it a PIMSy.
Yeah. Nothing? Right, then we're going to cut that. Yeah. Probably some notice would have been good on that question, I guess.
no, quickly.
You guys are hilarious.
No
Do that
worries.
again.
PPS leases, that's one of our future topics, so keep an eye out.